All right. Hi, how are you today? My name is Felipe, and this is Legal English. Well, as in our previous videos, we have portrayed how is justice served in California, how is justice served in the United States, but also how do we speak English? Sometimes for lawyers, it's very difficult to understand some meanings. The way we use law here in the United States, it comes also with advocacy, with the training, with the good communication skills that you may have as a citizen. So sometimes what we lack is of good communication skills. Sometimes what we understand about the law is the wrong portrait of the law. So the matters of the law are understanding what are the key concepts of the law. How is the law making new progress for you? How is the law in any matter the prevention of also another crime? So today it's going to be about a game. Usually in movies, we see something about an objection. Objection, Your Honor, objection. So we all the time say objection, objection. But how do we really make a motion? How do we move? The word motion that we have here, it's about movement. It's about moving away. So when we say motion, it means to move. Okay, so motion is movement. That's why we say motion to disclose evidence. Motion, 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 motion. So we're going to use motion, okay, because it's a movement. And they're going to say objections, which is the opposite. You're going to object. You're going to stop something. Okay, so motion, objection. Motion, objection. Repeat after me. Motion.
Motion.
Very good. Again, motion.
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 Again. Okay, very good. Fernando, please.
Motion.
Excellent. Objections.
Objection.
Very good. Very good. Again, objections.
Objections.
Very good. Now, so let's understand some of the key objections. We have more than 21 objections in court, okay? And there can be more. According to every court, remember, here in the United States, we have 50 states, 50 legislations, 50 kinds of making justice. But in general, there are the key concepts about the procedure. The procedure is the same because we have a criminal code. So the criminal code states something, but that something, it always has to relate with how the law is in due process. So the due process of law is always the same, but according to every legislation, according to every state, we're going to check how motions are going to be different. Here in California, everything is going to be for the human. We're going to try to check how the things were done, but also how to protect the human in any case from any matters that can decrease, that can undergo, or can harm, that can cause any harm to our witness, to our client. Okay, so let's see what are the main objections that we have about the law. So the first objection that we have it's the definition of the word objection. So in a court setting, an objection is a formal statement made by an attorney during a trial to protest or challenge a particular line of the questioning, the introduction of evidence, or other procedural or legal issues. The purpose of an objection is to call the judge's attention to what one party considers an improper method, evidence, or procedure being used by the opposing party. Again, in a court setting, so we're talking about court, okay? This doesn't work outside the court. Sometimes we can subpoena a person, okay? So if there is an affidavit by a subpoena, well, the judge has to review the subpoena. But the affidavit, it means the statement, the declaration, as we say it in Spanish, that the person says, that it's the affidavit. So the affidavit is how the person actually thinks the facts were done. But the objection is quite the opposite. In the objection, we're going to stop. We're going to say, no, this is not what I think. I think you should check. Check, judge. A, check, check. So instead of saying check, we say objection. Now, when we're talking about objections, we have to understand that objections are not meant to be used all the time. So you don't go, objection, Your Honor, objection, because the judge is going to say, hey, what's wrong with you? Okay. So they don't do that. So you have to have a reason. So that reason, it's going to be, why are you using the objection? You can use the objection to introduce evidence. Okay. So if you're trying to make the evidence be part of the process, then you're going to use an objection. Okay. But also another procedural legal issue is to challenge, is to say, I don't agree with this. Check. As I said before to you, the judge is not the person that judges a person. It's the jury itself. Okay. So the judge is only going to listen and is going to observe that the law it's mandated. But that's it. The job of the jury, which is any person, the jury, it can be any person from outside. That people that come together in a civil matter or in a criminal matter are the ones that are going to be the litigants. So the litigation itself is going to be opposed or not by an objection. Okay, so the purpose of an objection is to call the judge's attention to what one party consider, just consider, it doesn't mean that they're right, on improper method, an improper evidence, or procedure being used by the opposing party. Okay, Ulises, yourself, in a court setting.
In a court setting.
Continue. An objection.
The objection by an attorney during a trial to protest or challenge a particular line of questioning, the introduction of evidence or other procedural or legal issues.
Okay.
The purpose of an objection, yes.
So instead of saying problems, you don't say legal problems. You say legal issues. Okay. Never say the word, I have a legal problem. You don't say that. You say, I have a legal issue. Okay. Again, continue, please, Marisol. The purpose.
The purpose of an objection is to call the judge's attention to what one party considers on improper methods, evidence, or procedure being used by the opposing party.
Very good. Fernando, in a court setting.
Excuse me, teacher, I am driving.
Oh, you're driving? Okay, no problem.
Okay, thanks.
Okay, no problem. In a court setting, an objection is a formal statement made by an attorney during a trial to protest or challenge a particular line of questioning, the introduction of evidence, or other procedural or legal issues. The purpose of an objection is to call the judge's attention to one party considers an improper method, evidence, or procedure being used by the opposing party. Okay, I'll continue, but we'll go back to this definition. So what is the first objection that we're going to be using? The first objection, or the most common one, is to say objection, relevance, Your Honor. Every time you say an objection, you state what is the objection about. So the first objection that you're going to say is relevance. So you're going to state how relevant is the question to the matter. For example, if we're in a crash accident, right? And in a crash accident, says the lawyer starts saying, okay, so did you kill the person? No, that is not the matter. It's not relevant because that's part of the question. So you never go to that end. But if also the lawyer says, okay, can you give me the statement, your financial statement? How much money do you make? What's the point in that? Relevance again. So when an attorney objects something that is not correct. I mean, it's like, what is this about? So you're gonna say objection, relevance. Again, pronunciation, relevance.
Relevance.
Very good. Again, relevance.
Relevance.
Very good. Ulises?
Relevance.
Very good. So if the judge thinks you're okay with that, he's gonna say sustained. Again, pronunciation, sustained.
Sustained.
Very good. Ulises?
Sustained.
Good. If the judge thinks you're incorrect and is not going to give you the motion, you're gonna say overruled. Again, pronunciation, overruled.
Overruled.
Very good. Again, overruled.
Overruled.
That's right. Ulises?
Overruled.
Very good. So what is the relevance? It says an attorney may object if the opposing counsel, pronunciation counsel. So when we're in court, we're not lawyers anymore. So we say counselors. So we are counseling the parties. We are not litigants. No, not litigants. We're counselors. We may apply techniques of litigation, but the litigation is the process, is the activity. But here we're counselors, so we counsel service. So an attorney may object if the opposing counsel's line of questioning, or a piece of evidence is not directly relevant to the case. It's not relevant. So, for example, if I say, so, do you speak English? That's not relevant. Not relevant, so it's relevance. Objection, Your Honor, relevance. Okay, very good. So if the judge thinks you're correct, then he's gonna say sustained. Again, pronunciation, sustained.
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 Very good. Or overruled. Again, pronunciation, overruled.
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 Very good. Next. Hearsay. Again, pronunciation, hearsay.
Hearsay.
Very good. Again, Ulises, hearsay.
Hearsay.
Right, very good. What is hearsay? It's something that you don't know if it's right, something that you assume it's right because you listen to another person. Example, oh, Felipe. Yes, Felipe is Chinese. Me? Chinese? That's hearsay. Who told you that? Yeah, somebody told me you're Chinese. I'm not Chinese, I'm Mexican. No, you're Chinese, teacher. Okay, that's hearsay, okay? Again, pronunciation, hearsay.
Hearsay.
Very good. Ulises? Ulises, are you there? Okay, he might not be there. Okay, so hearsay is an objection raised when a witness is testifying about a statement. Very good. So the objection is raised when a witness is testifying about a statement made by somebody else outside of the court. So if the information is not on file, or is not in the court, or is not the matter that we're attending, that is called hearsay. Even if it's to prove the truth of the matter asserted. Okay, so even if it's right, even if somebody else told them about this, that information cannot be part of the court. Why? Because it wasn't offered previously. Why? Because that person is not the one that heard, saw, or even lived the thing itself. So that's, we call it hearsay. So if the judge thinks you're okay with that and says, yes, probably you're right. He doesn't know about the things, that probably just a lie. So he says, sustained, correct. If not, he's gonna say overruled. Again, pronunciation, overruled.
Overruled.
Right. Sustained.
Sustained.
That's right.
Sustained.
Very good. Sustained.
Sustained.
Okay, Ulises.
Sustained.
Sustained. Very good, Fernando. So let's continue. So misleading. We have to be careful with this. Okay. We have to be careful with this objection, because the misleading, it's one thing, and leading to questions, it's another.
Sustained.
Very good. So we're right now on misleading. So what is misleading? When an information is not pointing or is trying to persuade the witness. The witness cannot be persuaded. He either knows something or he doesn't know anything about it. Let me say it. Example. Hey, so you were late last night. Is that correct? Hey, he cannot make assumptions like that. He's trying to lead to a question. So a question cannot go for another question. So he's misleading the person who is saying. So we say objection, misleading, objection, misleading. It means that person, the lawyer, the attorney, the counselor, is trying to get another question or is trying to get another answer without actually saying something from the truth. Okay, the important thing here in the United States is not how things happened. It's the truth. It's how really the evidence is going to sustain all of this information. That's why we say sustained if the judge thinks you're correct, or overruled if he thinks you're not correct. Okay, very good. So let's go to another answer to this. So it says leading questions. During direct examination, an attorney may object if the opposing counsel asks leading questions, which suggests the answers within the question itself. Okay, so he cannot lead an answer to the question or taking the question to another question. Next. A speculation. Repeat after me. A speculation.
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 Again, Marisol?
Speculation.
No. A
No.
speculation.
Speculation.
More like you. A speculation.
Speculation.
Okay. Speculation.
Speculation.
Again, a speculation.
Speculation.
That is correct. Okay, so a speculation is an objection that may be raised if a witness is asked to speculate or guess about something they do not have a direct knowledge of. For example, so Felipe, you say you speak English. Yes, I speak English. Felipe, do you know the difference between legal English and physics? Yes, physics is about physics. I'm guessing. It's not my area of expertise. So I'm not going to say anything because I'm not accurate. So I'm just guessing. So don't assume. If the witness is assuming and he doesn't know about it, and you know that he's not understanding either the question or he's just guessing, like, so you think this man is guilty? A, objection, speculation. Objection, the witness doesn't know anything. Objection, speculation. Understood? Ulises, can you hear me?
Yes, I can hear you.
Okay, very good.
Hello, can you hear me?
That's better. Yes, that's better.
Hello.
Yes, I can hear you. That's a lot better. Now I can hear you. Okay, very good. Ulises, repeat after me. A speculation.
Speculation.
Very good. It's an objection that may be raised if a witness is asked to speculate or guess about something they do not have direct knowledge of. So if you ask me, Ulysses, so teacher, you're an expert in cybersecurity. Sure. Okay, so if you're an expert in cybersecurity, please tell me what's the difference between JavaScript and C++ and a difference between a honeypot. I mean, too many things at the same time. I'm not gonna guess all of that. So that is speculation. Okay, very good. So if the judge thinks you're correct, then he's gonna say sustained. If the judge thinks you're incorrect, he said overruled. Okay, again, pronunciation, overruled.
Overruled.
Okay.
Overruled.
Overruled. If the judge thinks you're correct, they're going to say sustained. Again, pronunciation, sustained. Everybody.
Sustained.
Very good. Sustained. Very good.
Sustained.
Next, let's go to the next objection. So the next objection is expert testimony. Okay. When a witness who is not qualified as an expert offers opinions or conclusions that require a specialized knowledge. Okay, so it's very important, this one, especially with you guys that are experts in cybersecurity or in cybercrime. Okay, so if you're, listen to this, if you're offered just as a normal witness, you cannot talk about things about your specialty, even if you are, because you were not given as a forensic or witness expert. Okay, so even if you're an expert, but you're not required to provide evidence about that, then you call it objection, expert testimony. So he's gonna say, but he's an expert. Yeah, but he's an expert, but he was not offered at this time as an expert. That's one. Two, if a person, a normal person, is asked something very specific, for example, let's say, so you like to drink, right? You like to drink. Sure, I like to drink. So in that night, you drank with the defendant. Yes, we had a drink. So you know that the defendant is the person that is there. Yes, I know that defendant is that person over there. Very good. So can you tell me what's the difference between alcohol and the measures of the alcohol and 90% alcohol or 20% alcohol? Objection. He doesn't know anything about alcohol, even if he drinks alcohol, because that's about sommelier. It's about a specific knowledge. So if it's a specific knowledge and you don't understand anything about it, so that is called objection. Expert testimony. Okay, again, repeat after me, everybody. Expert testimony.
Expert testimony.
Very good. Okay, expert testimony.
Expert testimony.
Very good. Let's go to the next one. The next one is going to be argumentative. That's a long word, so listen carefully. Argumentative. Again, argumentative. Again, argumentative. Argumentative. So let's go faster. Argumentative. 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 Okay. Let's listen to this. It's kind of the same that in Mexico, but it says, this is used when a question is phrased in a way that challenges or provokes the witness. Okay. But it provokes the witness to say something different that it is expected to say. Let me say it like this. An argumentative question is that you're either saying the answer itself, you're misleading, or that you're putting extra information. So if you're putting extra information of what you're asking, then it's argumentative. No extra information. The question is very simple. Did you drink on October the 29th with this person? Yes or no? That's it. if you start saying, so you said previously that you drink, yes. But at the same time, you say you drank with that person. So if that person drank with you, does that mean that you're considered an alcoholic? Objection, argumentative, and also speculation. So it can be actually both. Why? Because you're getting extra information. Never get extra information because you're trying to leave a wrong question. So it's argumentative. Okay. So again, if the judge thinks you're correct, he's gonna say sustained. Yes, don't answer to that. If the judge thinks you're incorrect, he's gonna say overruled. Okay, next. Badgering the question. Again, pronunciation, badgering, badgering, badgering,
Badgering.
badgering. Again, badgering.
Badgering.
Okay, very good. Marisol? No? Ulises? Badgering?
Sorry. Okay.
Badgering.
Badgering.
No? Badgering. This is a
Badgering.
DG, so we say
Badgering.
badgering. Badgering.
Badgering.
Okay. Ulises? Badgering. Ulises? Huh? Okay, what is badgering the witness? When we say badgering the witness, it means that we are trying to protect the witness from bringing aggressive, repetitive, or harassing questioning. So if the lawyer is already being too aggressive with our witness, we say, objection, you're badgering the questioning. Objection, you're badgering the witness. Objection, you're badgering the witness. Objection, repetitive. So also you can go like this, repetitive. Okay, objection, repetitive. Objection, you don't say aggressive. You say badgering the witness. Why? Because he's being aggressive. Or it's a harassing question. What is harassing? Repeat after me, harassing. Can you hear me? Marisol, are you there?
Yeah, I'm here.
Okay, repeat after me, harassing.
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 Very good. There are two very different meanings. One is molesting. Molesting exists, especially in legal terms, but that is a sexual touch. Okay, that is molesting. That is, so we don't say don't molest the witness. No, we don't say that. We don't say that. Molest, it means to touch physically. Okay, so that's molesting. Harassing is when you're being aggressive and at the same time you're making you cry, for example.
Okay.
Oh, Felipe, yes. So, so your uncle died, right? He died. I'm so sorry. Hey, I'm gonna cry. It's my uncle. So if you're trying to hurt my feelings, that is badgering also the witness. Okay, so we're gonna try to protect the witness as much as we want. So again, badgering. Pronunciation, everybody. Badgering.
Badgering.
Very good. Again, Fernando, badgering.
Badgering.
Excellent. Ulises?
Badgering the witness.
Exactly. Very good. So if the judge thinks you're correct, he's gonna say sustained, or if he thinks you're incorrect, he's gonna say overruled. Okay. Next. Privilege. Oh, this is so important, the privilege. I love this objection. Why? Because when you have a non-disclosure agreement, it means an NDA. If you have an NDA about information and you're trying to use that information in court, that is invalid as long as you fight it in court. If you don't fight it, if you don't object, then you can use the information. So you say, objection, Your Honor. The witness signed a non-disclosure agreement for that information. So, objection, that is underprivileged. So if it's underprivileged, he cannot talk about the information he signed previously with an NDA. Okay, so privilege is raised when a question touches a confidential information protected by law. So if it's a secret that it wasn't offered before pre-trial or in trial, or in any case in any legal discovery, so he cannot bring it up in the questioning. Okay, such as an attorney-client privilege. Example: last time, Ulises and I, we were checking how the information goes between a client and the defendant. If that information that the client spoke to me as the lawyer, and all of this information is used in court, in that case, we're saying that there is a privilege. So that information cannot be used in court. Even if the police officer says, I know that he's guilty because when the lawyer arrived, he confessed to the lawyer. That information, again, it's privileged. So you cannot use it in court. Okay? But listen to this. Listen. If the attorney uses that information, but the other counselor doesn't raise any objection, then it is legal because he didn't say it. He didn't defend it. That's why, as a lawyer, your job is to defend the information that is being used against you. Okay? Again, pronunciation: sustained.
Sustained.
Overruled.
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 Okay, so we're calling privilege. Next. Right, very good. Everybody, repeat after me. Privilege.
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 No, again, privilege.
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 Okay, very good. Next. Cumulative evidence. Repeat after me. Cumulative.
Cumulative.
Very good.
Cumulative.
So usually you only say objection and one word. You don't use both, but you're asked to say why. So you say cumulative evidence. Cumulative evidence. Cumulative evidence. Practice. Practice. Cumulative evidence. Cumulative evidence. Cumulative. Cumulative. Cumulative.
Cumulative.
Very good. Is information used when similar evidence has been presented multiple times and is hence redundant? So you can also call this objection as redundant. Okay. So redundant or cumulative evidence, it means that that information has already been presented before. So if they, for example, today in the focus group, we were talking about a condom. Okay, a condom, just a condom, right? So they were saying, okay, so the condom. So on discovery, we knew about the DNA was a result of this positive idea. So the condom again, and the condom, and the condom, and the A. That's cumulative evidence, Your Honor. Objection, cumulative evidence. We have already discussed the information before, so we don't use it anymore. Okay, again, pronunciation, cumulative evidence, cumulative.
Cumulative evidence.
Very good. Or you can also say redundant. Objection, redundant. Why redundant? Oh, objection, Your Honor, is cumulative evidence. It's redundant. Okay, very good. So we say sustained or overruled. Next. Let's see if you understood. Practice makes progress. So keep on practicing. Relevance. Again, pronunciation, relevance.
Relevance.
Relevant.
So you say
Relevance.
objection, relevance. Again, pronunciation, objection,
Objection.
Objections.
relevance.
Relevance.
So when you're talking about relevance, let's use this example. In a car accident, for example, the attorney asked the witness about the defendant's financial status. Objection, Your Honor. Relevance. The defendant's financial status has no bearing. Pronunciation, bearing.
Bearing.
Very good. Everybody, pronunciation, bearing.
Bearing.
on the facts of the car accident. So we say that it has no bearing. Again, pronunciation has no bearing. Has no.
No bearing.
So you don't say. So you don't say what's the relationship. No, you don't say that. So what's the relation? No, not relation. Not relation. Okay. So what's the relation? He kissed the mother, and this is nah. So we say, what's the bearing? Again, pronunciation. What's the bearing?
What's the bearing?
On the facts.
On the facts.
On the facts.
Very good. So you say, objection, Your Honor. Objection, Your Honor. Again, pronunciation. Objection, Your Honor.
Objection, Your Honor.
Very good. Relevance.
Relevance.
Relevant.
Very good. So let's practice with one more before we go. Hearsay. Again, pronunciation. Hearsay.
Hearsay.
Again, hearsay.
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 Well, some people call it chismation, right? But it's not chismation. So we call it hearsay. So hearsay is when a witness testifies. For example, my friend told me she saw the defendant running away from the scene. So you don't know. No, I don't know. It was my friend. Aha. So if it's your friend, so you don't know. So that is hearsay. Objection, Your Honor. Hearsay. Again, pronunciation. Hearsay.
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 Very good. Ulises?
Hearsay.
Very good. The witness is attempting to introduce a statement made out of court. So if that statement is out of court, it's outside of court. We have no bearings. That's why we say we don't have any bearings here. Okay. To prove the defendant was at the scene. Very good. So let's go to the next one, which is leading questions. Again, pronunciation, leading questions.
Leading questions.
Leading
Right.
question.
Ulises?
Leading questions.
Or we can also say misleading. Objection, misleading. Objection, misleading. Again, misleading.
Misleading.
Okay,
Objection.
Misleading.
exactly. Ulises?
Objection.
Misleading.
Objection. Objection. The counselor is misleading the witness.
Exactly. Very good example. I love it. Very good. So let's go to see the example. During the examination, you saw the defendant at the scene of the crime, didn't you? Come on. I mean, you're blaming me or you're questioning me? Okay. Objection. Leading the question suggests the answer. Okay. So you never say the answer in the question. So you want me to answer what you're trying to get me to say in the question. Okay. So we're going to stop here the conversation because we have more objections to come. So we're going to check tomorrow if the objections are misleading or if we have any bearings. Okay. Thank you for coming today to the class. I'm going to start recording.